Good evening, friends. Before I venture any further into what I'm about to say to you all, I thought it's time I made a little confession as to how Sai Krishna Rajagopal decided to make intellectual property a career proposition. I was in my 5th year in law school. I met my wife in law school, and we had this subject called intellectual property. No, she didn't make me intelligent.
Then she was your wife?
She wasn't my wife at that point. She wasn't my wife at that point. But then we had I think in sometime in our second trimester of the year, we had intellectual property. And lo and behold, in a class of 54 students, 35 failed, including my wife. And there were recourses after recourses, and my wife was included in them. And in my desperation to ensure that my wife passes, I studied with her each time. But yours truly, I must confess, just about managed to pass in my first attempt. And then began an amazing journey with my first stint as a placement trainee in the firm of Anand & Anand. I was offered a job. I got married and came to this amazing city called Delhi. And what you've all seen in full view here is the kind of support and affection I've got from several members of the intellectual property bar. And what I've managed to do thus far is only because of that. And I think in that one respect, the intellectual property bar is very, very unique, at least in the city of Delhi. Although I'm going to focus on copyright law, I thought I'll give you a very, very quick overview of IP as I've understood it. Trademarks, as Chandar pointed out, is any indicia of origin. This indicia of origin could be in the form of a word mark like Colgate. It could be in the form of a symbol. It could be in the form of smell, color combinations, even the interiors or the ambience of a restaurant. In other words, any indicia of origin is capable of achieving a trademark signification. Patents, on the other hand, protects a protectable idea which is capable of industrial application. So, for example, we spoke a lot about the neem patent. Now, the neem patents have achieved a notorious reputation, and in my view, some of them wrongly so, because some of them do qualify for patent protection. I don't know how many of you know that the ingredient in neem that causes or brings about all these fantastic properties is a substance called Adhivakta. Now, one of the patents, for example, that has been widely and roundly criticized in the press is actually a process for extraction of Adhivakta from neem leaves. What is wrong in granting a process of extraction of Adhivakta from neem leaves that is both time and cost efficient? So, for example, if in the traditional context, it took, say, 100 people and 2 days to extract Adhivakta from, say, a kg of leaves, and if you could do so through a process or an invention in, say, 15 minutes, why should that not be granted in a patent? So, the point I'm trying to make is that one sees a lot of misreporting, propaganda in the press about a lot of our traditional knowledge being patented or monopolized elsewhere in the world. While yes, that has happened in the past, I would just urge all of you to dwell a little further so that you do not get misled into what was actually protected in some of the patents. Copyright, on the other hand, and I'll dwell in detail in just a while, does not protect the idea itself, because idea is protected under patent law. Copyright protects original expressions of ideas. Then you have designs. Design law protects how a product looks. So for example, if you have a watch or any other article, features of shape, ornamentation, surface pattern, all aspects that dictate the look of the product are protected under design law. Then there is another species of intellectual property called trade secrets. Now, a lot of the times there is an overlap between trade secrets and patents in terms of subject matter. Trade secrets and patents can potentially protect the same kind of subject matter. But then the question arises as to why they are different. The difference is this. Look at the Coca-Cola formula. A lot of times, when an inventor creates an invention, the company or the inventor will need to take a call as to whether they want to protect the invention through the patent route or through the trade secret route. The difference is simply this. If you adopt the patent approach, then you need to file for a registration. You need to file a patent application. And you need to disclose what the patent is. And once you disclose what the patent is, you get a 20-year monopoly. And I underscore the word monopoly. And what is the state doing? In return for you sharing the technology for the rest of the industry to exploit at some later point of time, the state is granting a 20-year monopoly as a reward. But supposing the inventor thinks, no, I don't want to go through the patent route. I want to, this is a product or an invention that has a longer shelf life. Like for example, the Coca-Cola formula. He or she will then say, I'll protect it through trade secret by treating it as confidential. And by doing so, such a person can theoretically get a right to perpetuity as opposed to a 20-year monopoly term under patent law. Now this does not mean that he doesn't disclose it to anybody in the world. Naturally, if a trade secret needs to be commercially exploited, employees, various other people would need to come in contact with the trade secret in question. So long as you disclose the trade secret under conditions of confidentiality, the trade secret remains protected in perpetuity. So the difference between trade secrets and patents is really this, although the subject matter will be the same, but the term of protection is different. One is in perpetuity and the other is a 20-year monopoly period. Another species of intellectual property that has thus far got statutory protection, has now got statutory protection, is geographical indications. Now Mr. Lal, for example, I remember during my younger days in the bar, he has pioneered litigation on behalf of the Scotch Whisky Association or on behalf of various Scotch manufacturers. Why is it that the Scotch Whisky Association is able to stop an Indian whisky manufacturer from calling Indian whisky Scotch or using any indicia of Scottish origin? Because Scotch refers to whisky distilled in Scotland. Champagne refers to wine made out of grapes grown in Champagne. Darjeeling tea refers to tea grown in Darjeeling. You can't call tea grown in Sri Lanka as Darjeeling tea. This is what you call geographical indications. And geographical indications in India now have statutory protection. Another aspect that I wanted to emphasize on, especially in the context of patent law and copyright law, is that patent law is a monopoly right, whereas copyrights are not monopoly rights. Now what do I mean by this? The reason why patent rights are monopoly rights is because imagine there are two laboratories working on a pharmaceutical product or research in parallel, the entity, at least under Indian law, the entity that applies for a patent protection first, the entity to apply first, fits everybody to the post, including that other research laboratory which was engaged in parallel development. And once a patent registration is granted, the patentee enjoys a monopoly right, excluding everybody, including those engaged in the independent development of that product, from commercially exploiting the invention which is the subject matter of that product. In stark distinction, copyrights are not monopoly rights. Copyrights are not monopoly rights because what copyright law protects are original expressions of literary, dramatic, artistic works and musical works. Now the word original simply means that it originates from that person. And so long as it originates from that author, it is protected as a separate copyrighted work. So for example, I may sit in this room and make, say, a painting. One of you might sit in another room and make an identical painting. Both are capable of independent copyright protection because one did not copy the other. They are original works emanating from each of us. And it is for this reason that so long as a work is original and has not been copied, both entities or multiple entities could simultaneously enjoy copyright protection, and it is therefore not a monopoly right.